Before we speak of insanity and the law, let us first pause to marvel at the wonder we are about to examine: the human mind. The mind is the masterpiece of creation, a universe within us, vast and intricate beyond measure. It imagines, invents, reasons, remembers, and dreams. It is the silent architect of justice, art, science, and faith, the wellspring of language, love, and law itself. Through it, humanity paints, composes, builds civilizations, and touches eternity. It is both the courtroom and the witness, the artist and the canvas. But in its brilliance lies its fragility. This is the same mind that composes symphonies can fall into confusion. The same intellect that reasons law can be silenced by delusion or distorted by disease. And when that happens, when reason is eclipsed by madness, medicine and law stand together at a difficult crossroads. The physician sees pathology, neurotransmitters, and neural circuits misfiring. The lawyer sees the collapse of mens rea, the intent that anchors guilt. Between them lies a profound question: when the mind itself is ill, can the law still hold the person responsible? That is the challenge and the compassion of our topic: the medico-legal aspect of insanity as a defense. For while the mind is capable of divine creativity, it is also vulnerable to human brokenness. And our duty as healers and jurists is to discern not only whether an act was committed, but whether the will that chose it was free or fettered by illness. Today, we will journey into that frontier where creation's most amazing gift meets the law's most difficult situation. What happens when the masterpiece of the human mind fractures and the very instrument of justice itself is on trial? By the end of this lecture, you will understand how insanity operates as a criminal defense, how mental incapacity affects civil acts, and how lawyers and physicians can collaborate in presenting a credible medico-legal case. Article 12 of the Revised Penal Code defines insanity as an exempting circumstance. This presumption of sanity can only be overcome by clear and convincing evidence showing that at the exact moment of the act, the accused lacked understanding of right and wrong or the capacity to choose freely. This first table introduces the conceptual difference. Legal insanity is a judicial determination of criminal responsibility, while medical insanity is a clinical diagnosis. The court decides liability. Physicians diagnose illness. This second table highlights application. In law, insanity removes guilt. In medicine, it guides treatment. Both intersect in forensic evaluation, but their purposes and outcomes differ. One concerns justice, the other healing. Insanity and mental incapacity. There is a difference. For the most part, When we talk of insanity, we associate it with criminal law, while mental incapacity in civil law. And these are governed by different laws. At its core concept, insanity in criminal law is an exempting circumstance, removing criminal responsibility, while in civil law, mental incapacity refers to the lack of civil capacity or consent, nullifying contracts, wills, or even marriages. So the focus of inquiry in insanity is mens rea, the capacity to know right from wrong and act with free will. While in mental incapacity, volitional and cognitive capacity to understand and consent is the focus. The timing of evaluation is important in criminal law. Evaluation should be focused on the mental state at the time of the crime. In mental incapacity, the mental condition when the civil act was executed is important, be it a contract or a will or marriage. And the proof is different. In criminal law, it's clear and convincing evidence, while in civil law, it's preponderance of evidence. The effect is also different. If there's an acquittal, there is a confinement until cured based on Article 80 of the Revised Penal Code. While in mental incapacity, the effect is an annulment, guardianship, or interdiction of civil acts. The medical focus in insanity is on psychosis or manic or schizophrenic episodes or whatever other illness causing total loss of reason. While in mental incapacity, the medical focus is on dementia, the intellectual disability, or cognitive disorder impairing judgment. So how do we evaluate this? In criminal law and criminal proceedings, a forensic psychiatrist or other experts in relation to mental abilities, and especially cognition, the ability to know what's right and wrong, is necessary to assess the criminal responsibility. While in mental incapacity, neuropsychology, geriatric psychiatry, or cognitive testing is important. Okay, the legal outcome is that in criminal law, there is an exemption from criminal liability and confinement in a mental facility. While for mental incapacity, the civil act is void or voidable, appointment of guardian or annulment of marriage. And the philosophical basis, lastly, in insanity is that it protects those incapable of forming intent. While in mental incapacity, it protects those incapable of giving informed consent. When courts examine the plea of insanity, they focus on three classical tests drawn from both common law tradition and Philippine jurisprudence. First, the cognitive or right-wrong test adapted from the McNaughton Rule remains the gold standard in our jurisdiction. Here, the question is not whether the accused ever suffered a mental illness, but whether, at the moment of the crime, he was so deprived of reason and intelligence that he could not understand what he was doing or recognize that it was wrong. This test emphasizes intellectual understanding, the mental capacity to distinguish right from wrong. Second, some scholars refer to the volitional or irresistible impulse test used in a few foreign jurisdictions. It considers whether a person, though aware that an act is wrong, was unable to resist the compulsion to commit it due to a disease of the mind. However, Philippine courts rarely apply this. Our law demands total deprivation of free will, not just diminished control or intense emotion. The threshold is much higher than temporary loss of temper or mental disturbance. And finally, the temporal requirement is crucial. The accused must have been insane during the exact moment of the act, not days before, not afterward. Evidence of past hospitalization or erratic history helps but is insufficient unless linked to the act itself. This rule prevents misuse of psychiatric evidence to excuse criminal conduct that occurred during a lucid interval. In short, the courts want proof that at that critical instant, the accused's mind was so deranged that he had no understanding or control of his act. When invoking insanity as a defense, timing and procedure are everything. Under Rule 116, Section 11 of the Rules of Criminal Procedure, the accused or defense counsel must formally enter the plea of insanity before arraignment or during trial and give notice to the court. This ensures the prosecution and the court are aware that the defense will rely on insanity and allows them to prepare medical evaluation and rebuttal evidence. If the claim arises only after judgment or during appeal, courts treat it with extreme skepticism unless new, compelling medical evidence emerges. Once the plea is entered, Rule 101 of the Rules of Court authorizes the court to order a psychiatric or psychological examination of the accused. This examination is not punitive, it is protective. The aim is twofold: to safeguard the rights of the accused by verifying their capacity to stand trial, and to determine whether confinement in a mental facility is necessary during the proceedings. The burden of proof rests squarely on the defense. Courts require clear and convincing evidence, a high threshold just below beyond reasonable doubt. This standard ensures that insanity claims are not abused. The defense must demonstrate not only that the accused was mentally ill, but that such illness completely deprived him of reason and free will at the time of the act. Medically speaking, this requires a strong linkage between psychiatric findings and behavior at the critical moment. Without that temporal connection, even a solid diagnosis fails legally. In insanity defenses, the Philippine Supreme Court applies the clear and convincing evidence standard, an intermediate burden that demands substantial and highly persuasive proof. It is not as strict as beyond reasonable doubt, yet it requires more than a simple preponderance of evidence. As defined in Black's Law Dictionary, the evidence must produce in the judge's mind a firm conviction that the accused was insane when committing the act. This standard balances fairness and caution. It allows genuine insanity defenses while guarding against abuse. In People v. Bonoan, The court explained that insanity need not be proven with absolute certainty, but evidence must clearly establish a total deprivation of intelligence or reason. Likewise, in People versus Madarang, mere emotional instability or eccentric behavior was deemed insufficient. Thus, to exempt an accused, the court must be firmly convinced, not merely persuaded, that the person's mind was incapable of understanding right from wrong during the act. The presumption of sanity is one of the strongest presumptions in criminal law. Every individual is presumed to act with reason and free will. Thus, the burden of proof lies squarely on the accused. The prosecution does not have to prove sanity. It is presumed by law. Thus, in People versus Bonoan, the Supreme Court clarified that while the defense need not reach mathematical certainty, the proof must clearly and convincingly show that the accused's reasoning and self-control were destroyed by mental disease. The trial judge must emerge from the evidence with a moral certainty that the accused could not distinguish right from wrong. This moral conviction is what transforms circumstantial or medical testimony into legal exemption. Psychiatrists help create this clear and convincing picture through coherent reports linking diagnosis, symptoms, and behavior. Without that linkage, even a strong diagnosis fails legally. For the insanity defense to succeed, two essential elements must be proven by clear and convincing evidence. Number one, complete deprivation of intelligence or free will. The accused must have been totally incapable of understanding the nature of the act or distinguishing right from wrong. Partial impairment, depression, or erratic temper does not suffice. In People versus Rafanan, the court stressed that insanity requires total deprivation, not mere mental disturbance. And number two, timing of the mental condition. The defense must establish that insanity existed at the precise moment of the offense. In People versus Turalba, the accused had a medical diagnosis of psychosis months prior, but no proof was that he was insane during the carnapping. The court rejected the defense because the illness was not contemporaneous with the crime. So psychiatrists must time anchor their findings. Lawyers must correlate medical records and behavior to the crime's exact time frame. The defense collapses if the disorder is proven only before or after the act. In insanity defenses, no single piece of evidence, not even an expert diagnosis, can stand alone. Courts demand a convergence of medical and behavioral proof that together satisfies the clear and convincing evidence standard. Let's begin with medical testimony. A qualified psychiatrist or psychologist lays the scientific foundation. Their testimony must not only identify the disorder, but also link it causally to the criminal act, proving that the condition caused total loss of reason or control. For instance, in People versus Bonoan, the psychiatrist's diagnosis of dementia precox, supported by hospital records, convinced the court that the accused act stemmed from psychosis, not intent. Next are the medical records, hospital charts, confinement summaries, prescription histories, which provide objective, verifiable evidence of treatment. However, this must be authenticated under Rule 132 to avoid hearsay objections. Their probative value lies in showing that the accused illness was real, treated, and temporally close to the offense. Mental health history strengthens continuity. If an accused has been institutionalized or repeatedly treated for psychosis, this demonstrates a pattern of impairment. Yet, jurisprudence like People v. Madarang warns that history alone is insufficient unless linked to the specific moment of the crime. Then we consider circumstantial and behavioral evidence. Witnesses who saw the accused muttering incoherently, hallucinating, or acting purposely, uh, purposelessly, rather, provide real-world confirmation of insanity. In People v. Panya, the court gave decisive weight to coherent post-crime conduct, showing how behavior can make or break the defense. And finally, lay testimony from relatives, neighbors, or arresting officers is often the human element that ties the clinical findings to lived reality. These witnesses can describe how the accused behaved irrationally, talking to unseen persons, weeping without cause, or appearing detached from reality. Behavior jurists readily grasp as signs of insanity. So, when medical history, hospital records, mental health history, and lay observations form a consistent narrative, they meet the threshold of clear and convincing evidence. The synergy of science and behavior, expert analysis supported by ordinary observation, is what ultimately persuades the court that the accused was legally insane at the time of the act. When the court finds an accused not guilty by reason of insanity, freedom does not immediately follow. Under Article 80 of the Revised Penal Code, the person must be committed to a mental health institution until declared cured by competent medical authorities and the court orders release. Rule 101 outlines the civil commitment process, a separate proceeding where the court designates a mental facility and supervises confinement. This ensures that acquittal serves the dual purpose of justice and public safety. Confinement is not punishment, but a protective measure, balancing the rights of the accused and the security of society. Under Republic Act No. 11036 or the Mental Health Act, confinement must always be humane. The patient must have access to treatment, rehabilitation, and periodic evaluation. The law also prohibits indefinite detention and requires periodic judicial review to determine recovery. Hence, this step illustrates the dual nature of insanity cases, where medicine treats and the law supervises. The doctor's certification of recovery and the judge's discretion together decide when the individual may safely rejoin society. The insanity defense succeeds only through genuine collaboration between legal and medical professionals. The lawyer ensures procedural timing, files the motion under Rule 116, and integrates expert findings into the legal argument. The psychiatrist or psychologist provides an evidence-based explanation of the mental condition and relates it to the accused conduct. A consistent medico-legal partnership prevents contradictions. For instance, a defense psychiatrist must align their clinical conclusion with the theory presented by counsel, both emphasizing total loss of reason or will, not partial impairment. As a reminder, experts should testify as objective witnesses, not advocates. Their duty is to truth and the court. Ensuring medical integrity supports legal fairness. Preparation determines credibility. The defense of insanity is not spontaneous. It is methodical and evidence-driven. Step 1. Early psychiatric evaluation. The defense should request evaluation immediately after arrest, ideally within 24 hours of custodial investigation, to document the accused's mental state while fresh. This ensures that any psychosis or cognitive derangement observed can be time-linked to the alleged offense. Delay weakens causality. Post-crime mental decline might be due to incarceration stress, not insanity during the act. Step 2 is the filing of notice. Rule 116, Section 11 requires formal notice to the court and prosecution. Failure to file this notice early allows the court to presume fabrication. The motion should attach preliminary psychiatric notes and a prayer for commitment under Rule 101. Step 3. Evidence collection. Gather hospital charts, psychiatric medication logs, EEG or MRI findings, and affidavits from treating physicians. Always secure certified true copies and chain of custody affidavits to satisfy Rule 132 on authentication. Step 4. Multidisciplinary coordination. Defense counsel, psychiatrists, and relatives must synchronize narratives. The lawyer builds legal framing. The psychiatrist reconstructs the mental state. The family provides behavioral context. This alignment eliminates inconsistencies the prosecution might explode. In insanity defenses, documentation equals credibility. Each record, affidavit, and examination must converge to show the absence of criminal intent at the precise time of the act. Insanity cases live or die on the quality of witnesses. Both experts and lay observers must complement one another. Expert witnesses. This includes forensic psychiatrists, neurologists, or clinical psychologists. Under Rule 130, Section 49, they must prove specialized training and experience in mental health evaluation. So, their testimony should, number 1, identify the disorder and diagnostic criteria based on DSM-5 or ICD-11. Explain how the disorder caused total loss of reason or will, and relate clinical findings to observed behavior during the act. In People versus De La Cruz, the court discounted psychiatric testimony that failed to link the diagnosis to the time of killing. Now we go to lay witnesses. Family members or bystanders describe behavior, talking to oneself, hallucinations, or aimless acts. In People versus Panya, consistent accounts of coherent post-crime behavior defeated the insanity plea. Thus, lay witnesses humanized the clinical findings, showing whether the accused conduct was truly irrational or merely unusual. Synchronization. Before trial, conduct a witness conference. Align timeliness, terminology, and tone. Consistency between the psychiatrist's report and the relative's recollections enhances reliability and prevents impeachment. So, as a medico-legal rule, science explains, observation confirms, credibility convinces. Trial presentation should tell a cohesive story from science to behavior. Opening with the expert witness. Start with the psychiatrist to lay the medical groundwork. Have them explain diagnosis, test results, and their opinion on the accused incapacity at the time of the act. Ensure the expert explicitly defines total deprivation of intelligence and free will, aligning medical findings with legal language. Second, corroboration through lay witnesses. After the medical testimony, call relatives or arresting officers to validate abnormal behavior. The goal is narrative reinforcement. What the doctor explains scientifically, witnesses confirm practically. Third is documentary proof. Mark hospital records, confinement orders, and prescriptions as exhibits. Authenticate through the record custodian to avoid hearsay objections under Rule 132, Section 20. Remember, unauthenticated documents, even genuine hospital charts, carry no evidentiary weight. Fourth, connecting the dots. Your closing line of questioning should lead to one inference. At the time of the act, the accused was utterly incapable of understanding or choosing his actions. The judge must see a seamless link between evidence, testimony, and legal standard. It is important to use clear, non-technical language. Judges are persuaded not by jargon, but by coherent reasoning supported by credible evidence. Proving insanity. These tools help evaluate cognitive functioning, personality traits, and the potential for malingering. The Minnesota Multiphasic Personality Inventory is a widely used self-report inventory that assesses a broad range of psychological conditions and includes validity scales to detect inconsistent or exaggerated responses. The Rogers Criminal Responsibility Assessment Scale is another one. It is structured to guide and assist in evaluating criminal responsibility by assessing factors like mental state at the time of the offense and the ability to appreciate the wrongfulness of one's action. The Slow-Bogen mental screening evaluation is a tool used to screen for mental disorders that may impact legal responsibility. It is interview-based and reviews collateral information. Now we go to projective drawing test. Projective tests involve interpreting ambiguous stimuli such as drawings to uncover underlying thoughts and feelings. While they can provide insights into an individual emotional state, their use in legal insanity evaluation is limited due to concerns about reliability and validity. The Draw a Person test assesses cognitive and emotional functioning based on the individual's drawing of a human figure. The clock drawing test is a test that relates to a person's competency to stand trial, and thus also for criminal responsibility. So as you can see in the figures, these are interpreted by the clinical psychologist or the psychiatrist. It's important to note that while these tests can offer supplementary information, they are not definitive for diagnosing insanity and are typically not central to legal determinations. Now, in classifying insanity in relation to mental disorders, there are two standards. One is from the US, the DSM-5-TR, or the Diagnostic and Statistical Manual, Chapter 5. And in Europe, they use the ICD, the International Classification of Diseases, with the 11th revision. These are the psychotic disorders affecting cognition. So you can see here that there are parallel classification both from the DSM-5 and also the ICD-11. So the conditions here are on the right: the schizophrenia, schizoaffective disorders, brief psychotic disorders, and delusional disorders. Psychotic disorders represent the core of criminal insanity cases. In schizophrenia and schizoaffective states, cognition and judgment collapse. Patients cannot distinguish internal delusion from external reality. However, the presence of psychosis alone is not enough. Behavior at the crime's moment must show disconnection from reality. Brief psychosis or delusional disorder must be proven to coincide with the criminal act to justify exemption. Here's a list of mood and affective disorders with cognitive impairment. Mood disorders can severely impair judgment and volition when accompanied by psychosis. A manic episode may create delusional confidence or omnipotence, leading to criminal acts devoid of moral reasoning. Conversely, psychotic depression can distort guilt into homicidal or suicidal acts. Catatonia, though rare, represents pure volitional incapacity. Patients may act without consciousness of movement. Forensic evaluation must confirm whether the episode's intensity reach the legal threshold of total deprivation, not mere emotional disturbance. Neurocognitive disorders and dementias. These undermine reasoning capacity and moral judgment over time. They often appear in civil, not criminal, contexts, such as wills, contracts, or guardianship. However, acute confusion or frontal lobe damage, as in traumatic brain injury, may occasionally create forensic irresponsibility. In practice, psychiatrists distinguish between chronic degenerative incapacity, which is civil, and acute cognitive collapse, possible insanity. In both cases, courts rely on neuropsychological tests such as the Mini Mental State or MoCA or executive function batteries to demonstrate cognitive breakdown. Organic causes blur the line between medical emergency and criminal act. A patient in delirium, seizure, or medication-induced psychosis acts without conscious control. Forensic analysts must determine whether the episode was involuntary and temporally linked to the crime. While ordinary intoxication is excluded by law, pathological intoxication or post-ictal epilepsy may absolve liability. The medico-legal key is proof of physiological origin, not mere substance use. Hospital documentation and neurologic findings such as the electroencephalogram, the CT scan, and the MRI are indispensable for credibility. Dissociative and stress-related disorders disrupt awareness and identity, leading to cognitive gaps. While these conditions seldom meet the strict legal definition of insanity, they may explain automatism or temporary dissociation during crimes of passion or trauma. For instance, a person in a fugue state may act without awareness of identity or consequence. Philippine courts treat such cases with caution. Psychiatric corroboration is required, and malingering must be excluded. Forensic psychologists often administer dissociative experience scales or trauma inventories to validate these claims. The key medico-legal principle is this: functional disorders rarely absolve guilt entirely, but may mitigate culpability by proving diminished volition or consciousness. Together, these 5 tables show the spectrum of cognitive impairment, from psychotic and mood disorders to neurocognitive, organic, and dissociative conditions, each demanding careful DSM or ICD classification and forensic linkage to the criminal act. Courts rely on this distinction not to medicalize justice, but to ensure that only those truly deprived of reason and free will are exempted from liability under Article 12, number 1 of the Revised Penal Code. Disproving insanity. Challenging an insanity defense involves undermining the credibility and sufficiency of the defense's evidence. Common strategies include proving lucid intervals. Prosecutors may argue that the accused acted during a period of mental clarity, leveraging the Revised Penal Code's presumption of sanity. Next is detecting malingering. Tests like SIRS, which I have described earlier, identify feigned symptoms, weakening claims of insanity. We can also highlight rational behavior. Evidence of planning, concealment, or post-offense actions suggest rational thinking, as seen in People versus Gumpal, where such behavior negated the insanity defense. Cross-examination targets the expert's qualification, methodology, or conclusions to expose inconsistencies. Challenging the expert testimony includes questioning qualifications, verify the expert's credentials, training, and experience in forensic psychiatry or psychology to establish their authority. Next is challenging methodology. Probe the reliability of diagnostic tools, sample sizes, or retrospective assessments, as this may be subjective or even incomplete. Next is exploring alternative explanations. Ask whether symptoms could result from substance abuse, stress, or malingering, rather than a qualifying mental disorder. Another is testing legal alignment. Ensure the expert's diagnosis meets the Revised Penal Code's definition of insanity, questioning whether the condition caused a complete deprivation of reason. In People versus Formigones, cross-examination exposed gaps in the expert's assessment, reinforcing the court's rejection of the insanity defense. Thorough preparation, including consultation with opposing experts, enhances the effectiveness of cross-examination. And by way of conclusion, in law, insanity is not merely a diagnosis, but the absence of reason at the moment of choice, a space where medicine explains, evidence convinces, and justice restores balance between compassion and accountability.